Hello everybody, a very warm welcome to our channel Indian Mass Communication. In this video lecture, we are going to learn all about Contempt of Court Act 1971 from the perspective of media law and ethics, and also from the perspective of freedom of speech and expression. We are also going to solve several PYQs which have been asked in your exam. So if you are new to my channel, my name is Tushar Goyal. I am a Ph.D. research scholar at Center for Media Studies, JNU. I have also qualified JRF and other media related exams. So if you have already not yet done, you can consider subscribing to our channel. There is an application and website where you can get digital access to a lot of our PDFs and previous year questions with detailed explanations. So the links to all of them will be in the description box. So my dear students, when we talk about contempt of court, in simple terms, contempt means being disrespectful or disobedient to court. So it is a crime of being disobedient or disrespectful toward a court of law and its officers in the form of behavior that opposes or defies the authority, justice and dignity of the court. So in a thriving democracy such as ours, where the judiciary is one of the pillars of our democracy, it is essential to maintain the dignity and the respect of the courts. When we talk about media and contempt of court, the Contempt of Court Act becomes very relevant because when we talk about media, we talk about things such as media trials. So in many circumstances, in many cases, media has been irresponsible with certain media trials in certain cases. The recent example being the Sushant Singh Rajput case, in which these news coverages were being responsible for interfering with court's judgment, or they were trying to create some kind of bias among the public opinion. So actions such as publishing material that biases the public opinion against a party in an ongoing trial, the contempt of court becomes very relevant. So when we talk about the Constitution of India, Article 19(1)(a) grants every individual with the fundamental right of freedom of speech and expression. But as we have already discussed about it in our previous lectures, that this fundamental right of freedom of speech and expression is not absolute. It comes with several reasonable restrictions. One among them is contempt of court. Our freedom of speech and expression doesn't allow us to disrespect or disobey the orders of the court. The rationale behind the contempt of court is that it maintains the dignity, but there is also a criticism, as the contempt of court is not well defined. What is contempt? So in many cases, several times it has been observed that this act also curbs the freedom of people to criticize or fairly criticize the judgments of court. So there has been a PYQ also in your exam, which article of Indian Constitution relates to the contempt of court. So among these options, Article 19 seems most perfect, because in Article 19(2), in reasonable restriction, there is a mention about contempt of court. Moving forward, there are several other articles in Indian Constitution which are related to contempt of court. So Article 129 and 215 of Indian Constitution give Supreme Court and High Courts the power to punish contempt. So Article 129, it gives Supreme Court the power to be the court of record. Similarly, Article 215 gives the High Courts the power, or they recognize High Courts as court of records. What does court of records mean? It means that these courts has the power to punish for contempt of court, including contempt of itself. Okay, so remember that Article 129 and 215 of Indian Constitution are also related to contempt of court. When we talk about contempt of court, there are two kind of contempts. One is civil contempt, which is covered in section 2B, and other is criminal contempt. So दोस्तों, अगर किसी व्यक्ति ने या किसी मीडिया हाउस ने, किसी जर्नलिस्ट ने कोर्ट के ऑर्डर्स को डिसओबे किया है, इट कम्स अंडर सिविल कॉन्टेम्प्ट. व्हाट इज डिसओबेइंग? सो लेट अस टेक एन एग्जांपल. सो देयर इज अ मैटर विच इज सब जुडिस, वो अभी कोर्ट में चल रहा है, एंड द कोर्ट हैज पुट एन इंजंक्शन ऑन ऑल द कवरेजेस till the time the matter is decided into court. If a journalist or a media organization still covers it, if they are still covering this matter, it becomes disobedient or disobedience of the court. So it involves willful disobedience of the court orders or judgments, or the willful breach of an undertaking given to the court. Then other is criminal contempt, which is mentioned in Article 2C of Contempt of Court Act 1971. It includes scandalizes. So अगर कोई publication या कोई matter कोर्ट की proceedings को या उसके judges को scandalize करता है, उनका नाम खराब करता है. Prejudice, if it creates prejudice or bias among the people, or it interferes with the due course of judicial proceedings. Third is if it obstructs or interferes with the proceeding or administration of the justice. So take an example. There is some kind of proceeding going on, and there is a journalist or some kind of media people who are interfering. They are coming again and again. They are creating nuisance in the court. So it is interfering with the administration of justice. So these 3 points comes under criminal contempt. Then when we talk about the punishment, so section 12 of Contempt of Court Act 1971, it covers the punishment. So what is the punishment for contempt of court? It is an imprisonment up to 6 months, a fine up to 2,000 rupees, or both. And also there is a provision of apology, provided that the accused may be discharged or the punishment awarded may be remitted on apology being made to the satisfaction of the court. So this is very important from examination point of view. Many a times in your exam they have asked what is the imprisonment time frame, or what is the fine of contempt of court if somebody is found guilty. So now let us discuss what is not a contempt of court, or what are the defenses of contempt of court. As we have already discussed that on one side it is very important to maintain the dignity, but it also curtails the freedom of speech and expression if it is not regulated properly. So in a free democracy, the citizens and the media houses, they should have the freedom to fairly criticize or talk about important judgments, because the judgments, it creates precedents, they create discourse in the society. The Contempt of Court Act covers several defenses. So innocent publication and distribution, if it is bona fide, done in with good intention, it is not contempt of court. Fair and accurate report of judicial proceedings is not a contempt of court. So as you already know that media has to report a lot of important judgments, important proceedings in the court. If it is fair and accurate without a bias, it is not a contempt of court. Then fair criticism of judicial act is not a contempt of court. So you must have gone through a lot of articles in several newspapers, opinion pieces. If somebody is fairly criticizing some judicial act, it is not a contempt of court. Then complaint against presiding officers of subordinate courts is also not a contempt of court. Then publication of information relating to proceedings in chamber or in camera is not a contempt of court, except in certain cases. Now let us also look at very important and controversial point from the perspective of our exam. So truth as a defense in contempt of court. If some judgment, if somebody is criticizing a judgment, or let's say there have been recent example of Prashant Bhushan and Kunal Kamra, where they are criticizing a certain judgment of a court, there might be some oversight, or people might feel that this particular judgment has been wrong. So truth as a defense. In 2006, the Contempt of Courts Act 1971 was amended to include truth and good faith as a defense. So if some person is criticizing a judgment or a judge and it turns out to be truth, then it is also not a contempt of court. So section 13, it talks about truth as a defense. Section 13 talks about contempts not punishable in certain cases, justification by truth as a valid defense. So something which is truth becomes valid defense on the condition that it is in public interest and the request for invoking the said defense is bona fide with good intention. So guys, there has been a question in UGC NET Journalism and Mass Communication. This was July 2016, question number 13. The question reads, truth of a statement is not a defense against. We also discussed this question when we were learning about defamation. The answer given by NTA is contempt of court, which is unfortunately wrong, because section 13 clearly states that justification by truth as valid defense if it is satisfied that it is in public interest and it is with good intention. So this question is actually wrong. It should have been claimed. So in defamation also, truth is also a defense against defamation. If we look at the other options, this option, official secret violation, seems to be more appropriate, because when we talk about Official Secrets Act 1923, which is an anti-espionage law which protects the official secrets of the country for security of the state. So this truth of the statement can be implied that whether it's a true document or there is some kind of truth, leaking the important documents or important facts about a country can lead to violation of security of state. So there is a small homework. Kindly go through this small act, contempt of court. It's a very small act, only it is covered in 7 pages. It is readily available on the internet, and go through section number 13, which clearly states that justification by truth as a valid defense if it is satisfied in public interest and good intention is a defense against contempt of court. Moving forward, there is also a limitation for actions of contempt of court. So the time frame to file a case against somebody is 1 year. So if this 1 year, no court shall initiate any proceeding of contempt of court either on its own motion or otherwise after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. So there has been a PYQ from this fact that the limitation of the action against contempt of court is 1 year. So guys, that was all from my side in this lecture. I'm going to upload this PDF on our study material group on our application, and there is going to be a full-length test of last 10-year PYQs on media law and ethics in the coming days. So thank you. If you found this video helpful, kindly like this video, share it with your friends and subscribe to our channel. Thank you.